So Serendip Training, actually, they provide training and courses in claims drafting and submission, dispute resolution, understanding, delays analysis and methodology, and contract management. If you require any more information, please get in touch with Malavan and he will provide whenever you need. Today we are going to discuss about 7 main topics. The first section is the contract management and understanding. Second section, we are going to go through the key role of the contract team in any project. Section number 3, we are going to go through the project changes and delays. Section 4, project claims and frustration. Section 5 is the claims determination and settlement. Section 6 is the lack of evidences and substantiation. And the section 7 part is obstinacy and resistance. Before to go through this, I would like to have the inputs of everybody who can share with us some of his experiences, why the claims always and most of the times go into dispute in the Middle East.
Hi, this is Malavan. Please feel free to ask questions. You can unmute your mic and ask. Mohammed, do you want to repeat the question?
Yes, please. We need to, prior to start, we need to have the inputs of the attendees based on their experience, how they think that claims always lead to a dispute in the Middle East, why we've got the highest rate of disputes in the Middle East.
Hi, good afternoon. My name is Raymond. Can you hear me, guys?
Yes. Hello, Sir Raymond. How are you?
Yeah, good. I'm Mohammed. Thank you. I believe one of the reason it could be attributable with the culture as well. That's one thing.
Okay.
Yeah.
Interesting. We are going to go through this. Any other question? Okay, let's move
Hello.
on.
Yes.
Yes,
Good
hello.
afternoon.
Yes, good afternoon.
Yeah, this is Naresh, sir.
Yes.
This is a contracts manager for Arton Holding.
Yes, welcome, Naresh.
This my question. So this disputes actually coming because of not timely notifications during construction and execution, because this is delay in notification to the client from the contractors, and they understand after completion of the task, they raise the variations, which the client, they don't have prior informations. So this is also the cause of dispute, and this is the cause of also, I think, in my opinion, this one.
Okay, thank you. Appreciate your inputs. Thank you.
Thank you.
Any other question? Okay, let's move on. So we are going to go to the section number 1, which is the contract management and understanding. So guys, everybody can see the slides. Okay, so we are going to give here a quick brief. We are not going to go through, I don't believe that there is a lawyer with us, so we are going just to give a quick brief about the differences between the common law and the civil code, which, like everybody shall know this prior to move on. The common law system is founded in the UK and spread through various countries, such as Australia, Canada, US, India, and some other countries. The civil code system is originated in Europe and implemented thereafter by many other countries, such as the Middle East, South America, and others. Why we need to go through this, just to give an understanding to all attendees that we are dealing in an industry and where the law applied here is the civil code. Washington University School of Law have defined the main differences between the two systems is that the common law countries is a case law in the form of published judicial opinions is of primary importance, whereas in the civil law system, codified state is predominant. But these divisions are not as clear-cut as they might seem. In fact, many countries use a mix of features from common and civil law system. Understanding the differences between these systems first require an understanding of their historical underpinning. Means people, they are coming through the common law systems, they have to make themselves aware about the civil code implementation, and especially in the Middle East, where we are moving forward on the slides. We are going to see many differences in the common law, which cannot be applied on the Qatari Civil Code or UAE Civil Code or Saudi Civil Code. Going back to the contract understanding, it's the basic information that everybody should know, which is the offer and acceptance. An agreement made between a parties consistent of various components. In order for it to be legally valid, shall have an offer from a party, the other party shall have an acceptance, and there is a consideration, a sort of qualification, which we've seen them, the people, they are involved deeply in the commercial contracts and procurement stages. They will see always bidders when they submit their offer, they will state something in the provision, which is the exclusions. Means they have priced the works and they have excluded some of it. So that's actually has to be properly reviewed by the contractor or by the client, and understand that the contractor has not considered, or the subcontractor supplier has not considered some particular of the scope, which has to be whether clarified, discussed again in order to be formalized. Therefore, before a contractor can be concluded, it is a contract to be concluded, it is necessary to resolve three issues. The first thing is, did the parties intend to be bound? These people, there is always an argument, in my opinion, about the letter of intent and the letter of award. In Qatar, people, they said, once we receive the letter of intent, we don't have any obligation to start with the works. What are the terms? What terms were essential and agreed? The major thing is the contract price, the project schedule, deliverables, the clear scope of work, that the contract, what is his obligation in terms of deliverables, and the parties agreed those terms, and what other terms were agreed in terms of liabilities, providing site facilities, storage, scaffolding. All of this has to be always taken in consideration, as this, I believe, in my opinion, this is the source of a frustration and disputes that goes always while moving on, progressing with the works. Those are formalized, are codified under the Qatar Civil Code, the law number 22 of 2019 regarding promulgating the Civil Code. So this, the people, they can have the complete information and the complete access to the Civil Code, where they can read what the Civil Code has identified regarding the laws. The fundamentals of contract management, the subsection number 2. Contract management is an art. It encompasses anything from establishing businesses through the relationship management and reviewing of performance. I do believe that people, they are involved on the contract management processes, they can see how much is this expertise is complicated, is frustrating while they are going through, especially during the initiation of any project, where they've got a very tight timeline to get all the subcontractor on board, to agree with them on all of the terms. They find always the difficulties on how to deal with the PVLs, the preferred vendor list, set by the employer or imposed on the tender documents to comply with. It is indeed split into two sections. The first section is the upstream. Upstream means the foundation of effective and successful contract management rely upon careful, comprehensive, and thorough implementation of pre-award activities. The focus should be on why the contract is being established and on whether the appointed party is able to deliver in services and technical terms. careful consideration must be given to how contract will work once it has been awarded. So here we are explaining the pre-contract stage during the tender stage or the bidding stage, how the team, whether from the contractor side or from the client side, whenever we are discussing about the tender processes, how people, they have to set up a very comprehensive and clear scope of work, payment mechanism, duration of the project, what are the obligations aside to the payment, aside to the project schedule, aside to the time delivery. So they have, both parties, they have to have the same understanding of the scope, the complete scope of work and the contract document itself. Anything, any gray area shall be identified and shall be cleared out before signing the documents. Downstream, after the contract has been formulated, the process turns to three main post-award activities. So the contract and commercial team always, they consider, or based upon the structure of the company and the structure of the project, they have three pillars that they have to take in consideration. Their services relationship. They have to ensure that the work is performed in line with the agreed terms, whether the obligation set in the contract, the general condition of contract, the contractor is fully complying with the terms and he's mirroring the same obligation to its subcontractor, which well known the norm of back-to-back basis. The parties' relationship, building and maintaining constructive relationship. It is very important for any contract and commercial team that to maintain a very strong relationship with the client, to ensure the first thing is, in my opinion, is the interim payment application to maintain a very healthy cash flow. Commercial contracts team, they have to have very strong relationship with the client and with the consultant to ensure that what is performed on site has been captured and billed to the client. In my opinion, this actually affects a lot the cash flow of the contractor in case of there is a bit of a frustration or a bit of disagreement on some of the terms of progresses on site. This will affect drastically the contractor cash flow. The contract administration, which is the formal management of the contract. Contractor, client, consultant, any stakeholders involved in the project shall ensure that they've got enough experts for them just to manage the whole contract administration life cycle, or else they will be in a position where they are going to have different breaches of contract, and it's going to lead to unnecessary conflict and might lead most of the time to a dispute. This we are going to discuss it in details in the upcoming chapters. The most successful contract management plan that, in my opinion, is the one that includes the upstream and downstream activities, both of them together, which I believe the pre-award activities, which we call the contract review, is very important to set the guidelines of the contract in order for the contract team to administer the project properly. I have seen many companies where they've got a disconnection between the pre-award stage and the post-award stage. You've got a team who's looking after the tender documents, who's submitting the tender, going through all the tender bulletin circulars till the project is awarded. Then the company will appoint a separate project team to administer what is already have agreed on by the team, which make it in some of the times is a bit complicated for the contract administrators, contract manager involved with post-award contract to manage appropriately the project. It is often an overlooked key skills. Contract management is not something to be handed to another department such as the legal. Contract management is the engine that drives true value across the supply chain and should stay only with dedicated professionals in the field. This quote has been extracted from the CIPS. So prior to moving forward, I want to see if there is any question on this section, so prior to move forward.
Mohammed, I just wanted to make an announcement. If anyone, like, we do have a problem with the bandwidth. So in case if that is a problem, please let us know so that Mohammed, the trainer, can repeat what he said. Thank you.
Sure, no problem. If you have any question, guys, please raise your hand so we can answer the question prior moving forward to the second section. Okay, fine. So we've got no questions so far. We shall move to the section number 2. So section number 2, we are going to discuss about the contract and commercial team role in any project. This actually, I have purposely inserted these slides just because this is one of the key that when we are going to see the research done by one of the biggest consultancies in the world, why project leads to disputes, which we are going to see it in the next slides. Contract managers plays a predominant role in any organization or project. This expertise requires particular knowledge and competencies considering the holistic responsibility they have to undertake, especially for large-scale and complex projects. I do believe people, they are involved in multi-million projects, they can see the liabilities the contractor is carrying towards the client and the same obligation and liabilities subcontractor they are carried towards the contractor. The importance of the role. Contracts commercial managers are accountable for various tasks, pre and post-award contract, and they take significant responsibility and required to take decisive decision. CMs are also deeply involved in the daily operation of the business projects and to ensure all obligations are met, rights are safeguarded, budget are met, and relationship is maintained. Contracts and commercial manager role is not limited only to the awarding the contract, negotiating the terms, the payment terms, negotiating the deliverables. No, it goes beyond that. They are during the peak of the project, they are in close coordination with the construction managers, construction team to ensure that all subcontractors, they are complying with their obligation, and the construction team, they are well spreading the resources throughout the project just to ensure that the budget are met. Or otherwise the project will go through out of control and nobody will have, if they've got the structure with strong projects control managers or projects control engineers, that they would give their inputs and their expertise and skills, and whether they need to identify where the project is an overrun in their reporting scheme. Here is an example of the tasks and responsibilities that the CMs they are carrying. Establish formation of the contract to the offer consideration and acceptance, provide expert advice and report to executive and board of directors, recognize and flag the common pitfalls in the contract formation, draft appropriate subcontract agreement. This is the purpose of mirroring the same obligation, same risk to the subcontractor, distinguish between the different ways of procurement works and how the risk profile differs, characterize varied forms of contract and effects of bespoke amendment upon them. Normally, contracts manager, they will draft the particular condition of the subcontract, and they have to always show the legal opinion, as some of the condition might not be applicable under the civil code, assess the contract mechanism and embedded pitfalls, explore the mechanism related to the extension of time, program, and delays. They have to understand the complete set of claims procedures and claims protocol set in the contract, what the client has put forward in terms of documents. Investigate the procedures for variation and loss and expenses, so they can see where they have the room to claim for variation. Critique the effectiveness of liquidated damages and contrast between the dispute resolution, the dispute procedures available to the parties. We are moving to the section number 3. Would like to know if there is any question regarding this section. If anyone has a question, please just raise your hand. Serendip, any question?
No. I think they are waiting for the most important slide. Right,
Okay.
let's go. Yeah.
I hope they are not sleepy, just they are not sleepy. Okay, we move on to the section number 3. We are going to discuss the project changes and delays. So what is actually a project change? A project change in the common practice known as a variation is an alteration to the scope of work in a construction contract in the form of addition, substitution, or omission from the original scope of work. The Royal Institution of Chartered Surveyor and the Institute of Building, they have different definition or different understanding in the way of terminology, how they have defined the project change, but the basis is the same. In my opinion, I have never gone through any project where I haven't seen any change, whether instructed by the employer or whether due to discrepancies on the design or due to the site condition where the original scope of work cannot be workable or achievable on site and require some alteration. Almost all the construction projects vary from design, scope, and definition. Whether it is a small or a large scale project, construction project will inevitably depart from the original tender design, specification, and drawings to many reasons. That's why any form of contract provide the parties to notify the other side on the challenges that prevented them from progressing the works as planned. Means there is a differences between the original scope of work the contractor has tendered for and the actual scope of work that the contractor has to carry. Contracts always contains provision for variation. Also, it can be agreed outside of the contract, but by a mutual agreement. For instance, we can take the example of FIDIC form of contract. The engineer has the right to initiate a variation by issuing an instruction or by issuing a request for the contractor to submit a proposal. In some other form, bespoke contracts, whether we take in, as example, Ashghal form of contract, Qatari DR form of contract, there is a different terminology, but the principles is maintained the same. The project delays, in a simple word, delays associated is the delay associated to any works. Like means if you've got any events that affecting the progress of the project, you have to notify it to the other party. Whether it is your own delays or somebody else's delays, always you have to keep the employer aware of the project issues. The delays associated to any event, issue, or matters likely to affect the performance of the works and render the contractual completion date unachievable. Means that you are notifying the employer, telling him, Mr. Employer, I would not be able to hand over your project within the contractual completion date agreed on due to these reasons. Then there is another mechanism to be explored by the parties. So each party has its own rights under the contract to look after his remedies. It is important to understand the types and categories which a delay falls into before analyzing delays. The delays are classified into 4 basic ways. We've got here, this is a general understanding for everybody here to understand the type of delays. We've got critical or non-critical delays. We've got excusable or non-excusable delays. We've got concurrent delays. We've got compensable and non-compensable delays. This we will explain it briefly at a later stage. So prior moving to the section 4, do we have any question regarding the changes and delays? Please, if you've got any question, just raise your hand. Okay, we shall move on then. Section 4, we are going to discuss about the project claims and frustration. The reason why we went through all of this section, just to have your inputs, guys, later on. Why do you believe claims leads always to a dispute in the Middle East? So this is giving a brief or refreshing your mind about all these processes that might be at a later stage the main issue of the dispute between the parties. The claims is identified as it's a variation orders or changes broadly linked to construction claims and are always a potential ground for delay or disruption. In practice, both change orders and claims are utilized frequently. Change order means anything deviated from the original scope of work. Delays anything beyond the contractor obligation or beyond the contractor control that has affected his progress. Change in the project requirements may have an impact on the terms such as the cost and the schedule delays. That's the reason why the contractor, he chose the way to follow the claim mechanism to seek for recovery from events or issues beyond its control. We are going to discuss here the type of claims, just headings. The contractual claims, we've got entitlement to an extension of time and the entitlement to additional payment known as a prolongation cost. And the extra contractual claims are common law claim, which is claims for breach of contract, relief from damages, compensation of damages, which has another mechanism and methodologies to be implemented. Claims handling. So we are going to go through with an examples during the post-award contract, how claims are handled by the parties. Contractual claims for time and cost shall stem from a particular clause of the contract. Where the expertise of contracts and claim consultant is identified, whether the event, like encountered by one of the parties, has a right to raise a notification and seek for recovery or not. For instance, we can take as an example, I believe that everybody is fully aware about the subclause 20.1, which allows the contractor to issue a notice to the client advising with the issues that might lead to a claim. The contractor must give notice to the engineer of time or money as soon as practicable and not less than 28 days after the date in which the contractor became aware or should have become aware of the event or circumstances. There is a long debate about, and there is a lot of articles about how to identify the contractor dates when he's aware, he became aware or should have become aware. There is a lot of arguments, and I believe in the 2017 version of the FIDIC has been amended. The supporting particulars should be served by contractor and should also maintain contemporaneous records as may be needed to substantiate the claim. So when you submit a claim, the engineer might come back and they will ask for some documents just to understand what happened on that particular month. For instance, you've got a six month cutoff date and you've submitted your claim, and the engineer would ask you from the month of January, he will ask you for instance, a site photo just to substantiate that you've been prevented from progressing the works due to the claimant reason. So the claimant has to always keep the records to provide it's an obligation under the contract to provide those records whenever it is requested by the engineer. The contractor should submit a fully particularized claim within 42 days after becoming aware of the relevant event. So what if the contractor fails to issue a notice within 21 days? Is the claim will be considered as redundant? So this, guys, a question for you. The case the contractor, let's say, for example, we pick up here and we've highlighted this section in red color because this is a particular condition the client choose to change the time bar from 28 days to 21 days. So if in case the contractor failed to issue a notice within 21 days, does the reservation of rights is there or not? This is the question. Do we have any question? Malaban, I cannot see who's raising his hand. That's why I'm asking.
Yeah, no one has raised the question. Chandrasekhar, do you have a question?
I don't have a question.
Hello.
I answered
hello.
I answered the question saying that there is a contractor has a right to raise even if it is more than 28 days if he is unnoticed about the event.
Hello. Yes.
Yes, hello.
So Muhammad, yeah, the same
Yes.
question was I asked before also the same. Is there right to claim after 28 days or 21 days if they did not issue any notice? And I think this is mutual agreement between client and if this is understanding, but by the FIDIC or by other condition of contracts, this is, I think the claim will be redundant. Yes. I don't know this one because I need also the answer of this one and what is the claim will be valid or will be postponed.
Okay, understood.
Yeah.
In my opinion, so in case that you've got an event, let's say there is an event prevented you from progressing the works on site, and you've got a time bar to issue a notice. Let's say in this case, we've got 21 days to issue a notice and notify the engineer that there is an event affecting our progress and we shall follow the contractual procedures to submit a fully detailed claim within 42 days. There is a provision in the Qatari Civil Code that provide the parties to have an understanding on why the contractor was at that point of time enabled to issue notice within 21 days. So this always need to have a sort and the inputs of a legal team, whether to have the time bar is implemented or considered under the civil code or not. I believe like people, they work in the UK, in Australia, the time bar is a legal obligation to all the parties that they have to issue notice within 21 days, or else they consider as the claim is redundant. The same applies to the liquidated damages, whether the parties, whereby the parties agree on a particular amount of value. We can say the example of 1 million riyal a day. In the UK, if you agree on that value, even the losses you have incurred is less than that, the judge will affect this, the condition agreed on. While in Doha, the judge has the right to ask the client to substantiate that he has incurred a losses which is equal or above the 1 million riyal. And then the judge has the right to take the decision which beyond the agreement between the parties. So this always it has to have a legal opinion and a legal firm decision about how you will tackle this. So this might be a significant events which the contractor have missed to notify, especially for design change. And I believe any contract managers, commercial guys, claim managers, this is the first thing they will do when they will receive a design change, prior to have the assessment from the technical team and how much from the QSs, how much the cost of these changes. They will issue immediately a notice, so to safeguard their rights. Later, at a later stage, they will decide whether to pursue that claim or not. This comes at a later stage, because in my opinion, whenever you have a time bar, so make sure that you issue a notice in line with the time bar in the contract, and avoid going to this legal argument whether the time bar is imposed by the civil code or not. This is, in my opinion, this is the way how I'm administering any change, any event on any project. The position of time bar.
Excuse me.
Yes.
This 21 days, this is from which date? This is from the receiving change order from the client, or from which date, 21 or 28 days?
Normally the 28 to 28 days. So the contract will specify exactly. So it's normally considered from the day when you receive the transmittal or the fax from the employer. That's the date on the stamp when you receive the stamp, the receipt stamp on the documents. That's the date when you start counting as a contractor. You have received the documents from the employer. From that date, you will start counting 28 days.
But in case we did not receive any fax or notice from the client, and if there is a change, and we did not receive any notification from the consultant or client, in this way, in this situation, is there is right for the contractor to claim the variation without notification from the client receiving any? You understand my question?
Yes, I've got your question. So if you visit back again, the clause 20.1, which is explicitly stating that as soon as practicable and not later than 28 days after the date on which the contractor became aware or should have become aware of the event or circumstances. Let's say, for instance, that you've got an instruction during the site walk. You've got an instruction from the engineer to change something, like let's say some of the finishes with some particular area, where the construction team has not failed to flow this information to you as a contract department. So what you will do, you can rely upon daily report, you can rely upon emails sent, you can rely upon any documents just to provide an evidence to the engineer that there is an instruction, verbal instruction, was not formalized at that point of time, but has been progressed by the contractor in a good faith manner in order to comply with the engineer instructions. So you can always find the room to rely upon some documents just to safeguard your rights.
Understand. Thank you.
Any other question? Please.
Yeah, I have a question here. Why there are two timelines, like 28 days and 21 days?
Yeah, this is what I've said. I've said this: the 21 days is an amendment on the condition. So the client choose to put 21 days for the contractor to issue a notice, while the standard form of contract of FedEx provide 28 days. This is with amendment, particular conditions.
Okay, thank you.
Thank you.
Yeah.
Any other question, please? Okay, we shall move on. So again, Fenwick Elliott, a UK law firm, has provided an explanation about the position of time bar in construction contract in civil law countries is different. Unlike the common law, where non-adherence to a time bar provision may render a contractor's claim invalid. Civil code may take a more lenient approach. This always you need to have a legal opinion prior starting administrating the contract. Once you have a time bar, just to issue a notice and to submit your claim, you have to have a legal review and they will give you their opinion prior to start implementing those mechanisms in the contract. The contractor may be required to conform with any time bar in the construction contract. However, some circumstances where it appears that the strict interpretation and opposition of time bar would be seriously prejudice the contractor may rely on certain provision of the Qatar Civil Code to urge a more lenient approach to be adopted. This includes the good faith obligation and unlawful of rights. Means you've got a series of delay events and changes within the project, and you have progressed with the works, but you have failed to issue a notice and inform the engineer within the time bar set in the contract. It might be 14 days, it might be 21 days, it might be 28 days. So it depends if the standard form of contract without or with amendments or without amendments. So the contractor should comply with that provision. However, you can receive an argument or a response from the employer stating that you have failed to provide a notice or to issue a notice in compliance with the time bar set in the contract. This where the contractor shall seek its entitlement under the civil code to see what the legal opinion or the legal lenient decision has to be taken in consideration, as this goes beyond the contractual provision agreed between the parties. The same thing that we've discussed in the beginning about the differences from the common law to the Qatari Civil Code or to any other countries that they use the Civil Code. So we are going to state here an example when a contractor is submitting an extension of time, okay, and he's claiming that he was delayed on the project due to the acts beyond its control, and he's requesting the engineer to provide a determination and to amend the completion date of the project. In principles, an extension of time does not automatically mean the contractor is eligible for an additional compensation, means a prolongation cost. An extension of time is not a prerequisite to an extra time or an extra payment unless you prove that. These are claims which are based on a clause or clauses from the contract and expressly provide the contractor to make a claim in certain prescribed situation. The FIDIC itself, we have taken here the example of the FIDIC, the recent version, 2017, red book, yellow book, and silver book allows for some of the clauses to provide the contractor to issue a notice. The clause 1.9, for instance, is the delay in necessary drawings or instruction, where the engineer or the employer delay the issuance of the drawings. Clause 1.13 is the employer delay in obtaining permit. This is always happening in this industry where you've got no DC1 approval, you've got no permit, and the client is instructing you to proceed with the works, as the contractor might expect some changes, some comments from any government entities, which might lead to abortive work. This has to be recorded, notified to the employer, telling them that I'm proceeding with the works without any permit provided. However, any risks, any abortive works might be encountered at a later stage shall be undertaken by the employer. Means the employer has to look after the cost incurred plus the timeline lost in order for the contractor to recover, to make a recovery on his program. The clause 2.1 is the delay in obtaining access to the site, which is happening in many projects, but always the engineer from the beginning seeks the contractor to do a mitigation. And this always, I believe, in my opinion, should be worked closely with the employer and to avoid any sort of, or being a claim oriented from this access to site, as sometimes the contractor delays its mobilization to the site. So as the contractor moving forward, he will find the room to mitigate those delays aside to the client delays. This is a tool used by the commercial and contracts team. They have to record that, but they have to point this and remind the employer and its engineer that despite this delays to giving access to the site, we've did in goodwill manner all the workable solution just to recover those delays. The clause 4.6, for instance, is an instruction for unforeseeable extra cooperation with others. Means that you've got an additional or an extra stakeholders involved on the project, which was not there during the tender stage as an interface matrix, and the client is instructing you to provide a cooperation with this party. It's happening always with the facilities management company, where they are appointed by the client in the middle of the project, and the contractor will be obliged to cooperate with any parties appointed by the client, which was unforeseen at the point of tendering to the works. The clause 4.7 is the error in setting out data, which is well known for everybody. 4.12, FEDEC provide unforeseeable physical condition outside. So this is in any site visit, none of the contractor can capture all the issues. It's impossible. So they might discover a condition on the site while they are progressing with the works, and they will raise this to the engineer. And I believe, in my opinion and in my experience, those site conditions, they will have implicit obligation on one of the party under the contract to comply with it. However, such issues has to be always dealt with in a cooperative manner for the benefits of the project itself. The clause 8.5, variations and foreseeable shortage in personal goods caused by epidemic or government section, or actions. So this actually provide the parties to raise a notification to the counterparty to state that I've got an issues that I cannot progress with the works. So the good example is the issue of COVID-19, where many companies they have faced a lot of issues in securing raw materials and materials from the preferred vendor list set in the contract. So the contractor shall seek the engineer support to deviate from the PVL with a technical reason, substantiated its position, and providing those as part of the mitigation and remedies that can be done at that point of time to avoid these unforeseeable events. We've got also the government action, the action taken by the Qatari government, imposing the closure of the industrial area, the preventive measures that all the contractors they have to adopt on site, which is actually affecting their rate of progress, and they're affecting their supply chain. So the contractor shall work on this closely with the engineer and explain exactly what's happening throughout the duration, where they've got some restriction to proceed with some works or to deploy resources, or how their progress has been actually dropped due to this or deteriorated due to this government interferences. And the Qatar Civil Code allows the contractor to claim time and a reasonable cost for any government interference, as long as he's maintaining the appropriate measures and rules, regulations set by the government. The clause 13.3.2, contractor required to submit a proposal for variation not accepted. The FEDEC version 2017 because sometimes that we've seen that the engineer reject the variation of the contractor without any reasonable reasons. So this clause has been amended and added to the form of contract, in where the contractor got a chance to submit a proposal for all this rejected variation, whether it is a settlement agreement or a proposal for a reduction of the cost incurred, just for the engineer to make its fair determination. Moving to the section which is frustration. So we would like to hear from you, what are the reasons of frustration? Frustration here, we mean that by why claims when is not settled properly or amicably agreed between the parties, why it's leading to frustration. We are not talking here about frustration of the project, means termination or termination by convenience. No, we mean by frustration of the claim. If the contractor submit a claim and it is rejected, and subsequently submitted another claim, it's again rejected, so there is no ground for agreement or consent between the parties. So it is going to be a frustration within the project, where parties they will lose the focus on delivering the project, and they will spend more effort in recording facts, recording issues, just to safeguard their rights. So I'm looking to see from your expertise and your experiences, what are the reasons of frustration in claims? I believe you've got many issues and many examples from your previous project, so we can have it as an example and can be shared by all the participants.
Mohammed, it looks like nobody has any frustrations. Are we in a perfect world? Please feel free to ask, share your experiences.
All the projects are progressing smoothly, so.
Okay, somebody has shared, he has mentioned collaborative behavior, uncollaborative behavior.
Okay, that's a good input actually, which we are going to discuss it at a later stage. So, in what sense that is its behavior?
Imran, would you like to share?
To explore more about this.
Yes.
Hello.
Yes, hello.
Yeah. What I mean by collaborative behavior, like, both the parties are just saying, oh, we are right, without going into the crux of the matter, that why the claims are coming. Both can't be right, both can't be wrong, okay? Need to understand each other's point of view. So, but for this, you need to have this flexibility to give each other a space, and I see it's not existent, or very, very less.
Yes, correct. So that's the reason why the standard form of contract provide the contractor rights to submit its claim, and provide the engineer rights to provide its determination. So at the end, those are the formal channel to submit your documents and to receive the documents from the engineer, seeing his position. And then definitely you need to have a round discussion explaining why, as an engineer, for instance, you have disagreed with the contractor allegation on some particular of the events, and why he's not entitled to that delay. So this is actually a technical exercise that has always to be done between the parties, and has to be fairly discussed always between the parties to reach an agreement on whether the contractor has the right for that particular impact or has no rights for that particular impact. So what I can say, what I can understand from question is that you are stressing that the upper hand part, which is most of the time the engineer, is rejecting the claim and putting more pressure on the contractor to go to the mitigation measures rather than asking for an extra time to complete the works. That's what you mean?
Is a part of it, I would say, but as one of my friends just discussed, it's not an ideal world. Okay, but the behavior issue is, to me, is one of the main. Like underlying thing is, if I would be very straight, egos is one of the main issue. Okay, and mostly, in my experience, if you've been able to manage the ego of your consultant or client or whatever it is, sometimes you've been able to get the claims which are not that clear as compared to the clear claims. So it's more, to me, a technical or contextual issue than a behavior issue as far as the frustration of the claims are concerned. And I totally agree that understanding of the contract and implementation of it is the key. But just coming to the point of frustration, why they don't come to the conclusion, it's inherited into behaviors rather than technicality, as per my experience and concern. I could be wrong.
Yes, I agree. I agree with you. So that's the reason why on the second slide that we have mentioned that the commercial contracts team, they are actually liable to maintain a good relationship with the client, even if things goes bad. So they have to be always there to support and provide the necessary information and the necessary support to the client in order for them to ensure that there is a middle ground for understanding between the parties. So there is always emotion goes into it. So the technical aspects of the analysis is always the ground for assessing any claim. So in case that you've got your claim in place, you have satisfied your contract obligation and you have submitted the whole required documents as per the claim protocol set in the contract. You are in a good position to negotiate, and you are in a good position in case things goes wrong, that your company have the whole rights to seek for all the recoveries. So you have to be always a supportive person, a supportive entity to the client, and whenever it is as you have stated, you have to satisfy their ego. So you need to be sometimes diplomatic with them, providing them the necessary information, being flexible, so doing some extra work out of charge just to show them your good faith and goodwill manner to have things resolved at the site level and amicably, rather than involving the company executive, the boards of directors, involving a legal team. So always try to cover those and try to resolve them at the site level prior being escalated. Do we have any other question? Okay, we shall move on. So, in my opinion, those bullet points below presented here are the root cause of why claims are being frustrated. So, the first thing is, in my opinion, is the absence of expert involved in the project, whether they are contract expert, delay analyst, or quantum experts. In some of the cases, you can have a project where you've got no expert involved from the client side to look after these matters, and where you're left with a technical argument which does not fit the purpose of it. So the contractor might struggle to have or to secure its rights at the site level, and he will be forced to escalate the things to the top management for their involvement. The second point is the employer's risk internal factors, which is the abuse of power of the engineer. So the engineer, he might have breached its duties under the contract. He might sometimes neglect or does not even respond to the contractor claims despite its reminders, its updates on the weekly report, monthly report, follow-up. He got no information, he got no backup, no status, nothing. There is unexpected problems and program issues. So in some of the time, sometimes that you've got a baseline program which is approved and it's full with mistakes, full with unlogical links between the activities, which is left both parties lost with the visibility for the required for the completion of the project. And we've got here the two sides, which is the retrospective and prospective analysis. So the engineer will be in a position where he has no room of determination, or he goes only to the rejection. So he don't give any provision for the contractor or any chance to reverse its submission, because he got a risk of non-understanding of the documents received. So there is a strategy of issuing many notices to cover every potential delay. We've seen contractors, for any single thing happening in the project, they will issue delays. They will issue a notice of delay. So this might raise a frustration on the engineer, and he might feel that the contractor, instead of spending more effort on managing their subcontractor and performing the works to deliver the project, they choose to issue notice for any single thing. Contract and commercial team, they have to always filter the issues coming from the site, coming from the technical, and they have to see, based on the program, is this event, it's going to lead to an impact on the critical path or not. Sometimes you might spend a lot of time, a lot of effort on notifying the employer, while the event has a float of 3 months or 4 months, or that activity is not at all critical and is not near critical. So the engineer will feel that you are wasting his time by issuing unnecessary notices. Effort spent in drafting and submitting a reasonable claim. An effective demonstration of entitlements means you are raising an event which the client is not culpable for, and you are trying to find a room to make him responsible for that delay. So by default, the engineer is going to protect himself and his rights in performing his duties, and is going to reject. And this might create a frustration. Lack of understanding of the technical aspects. So you might receive a claim as an engineer, and you might give it to a person to give him to, and request him or instruct him to give his determination as, let's say, delay analyst, but the delay analyst, he doesn't have the appropriate skills and knowledge to act or to carry on such function. So you will be left with wrong information received, where it's going to be responded to the contractor, and the contractor might issue a disagreement notice, and this will lead to frustration to the entire progress of the work. Delays in taking decision on critical matters. In most of the time, so I would like to state here that claims has no negative understanding. Claims is a tool set in any contract to inform the engineer, telling him, please, Mr. Engineer, I've got issues. I need your interference, please, to resolve these issues in order for me to maintain my schedule. It's not at all having a bad approach from the contractor just to be claim oriented or to seek an extra money because they are losing from the project. No, claims will never ever make any profit to any contractor. If you get a prolongation, you are going to have a cost reimbursed based on what you have incurred. That's it. You are not going to have any profit on it. So it's not very beneficial for the contractor to always seek for a claim. No, the delays in taking decision on especially critical matters, which falls under the critical path and needs the employer or the engineer decision, is one of the main reasons why it's raising frustration in the project, because the contractor, he might lose time to receive a response from the engineer, and he will be tasked after 2 or 3 months to recover those delays, which he has already notified the employer that this is a critical issues and needs an immediate decision. There is also the unfair entitlements and assessment of the impact. So the impact might be seen as a minor impact on the eyes of the employer, while the contractor, he will say this is a significant impact, I cannot progress with the work, and my program has been drastically impacted, I'm going to submit my claim, and please review these delays. You might have a delays due to any other parties appointed by the employer. So all of those are the main reasons, from my opinion, that lead always to frustration. So any other thoughts from your experiences, guys? I believe there is many other issues that leads to frustration. I haven't covered it all, so I didn't want to make it a bit long. So those are actually the main things which I'm actually encountering like frequently on the project, and I believe that.
Excuse me.
Yes.
Hello.
Yes.
Yeah,
hello.
these all points are very good regarding this frustration. The other one point coming in my mind is because of the documents, like what you say is correct, like as per procedure, if the non-BOQ items gets more frustrations because not proper submission, or there is a playing for the 3 quotations what we have written in the FIDICs, or any condition that contractor submit 3 quotations for non-BOQ items. So mainly this sometimes frustrations are coming because of lack of documents and not proper procedure for submission, like the rates, there is a frustrations and these things in the rates only sometimes. Yes?
Yes, correct. I do agree
for
with
non-BOQ item. For non-BOQ item only, there is a more changes coming, and there is a more difficulties for the consultant to finalize the variations. For BOQ item, okay.
Correct. Then aside to this, there is a non-BOQ items and also the provisional sum items. So provisional sum items, on some of the time, the employer and the engineer, they take their sweet time to decide on the particular package for a provisional sum. It might be all under the critical path, where they have decided to just postpone it, or change the design, or change the supplier, or change the specs, or negotiate the price because of commercial purposes. It can be a facade, glass facade of a building. It can be a furniture. It can be anything which might fall under the critical path. And when it comes to the nomination, it will be instructed. An ITP is issued instruction to proceed, is issued to the contractor to engage himself contractually with the nominated subcontractor. You might find difficulties for the parties to reach an agreement. The contractor won't reach an agreement with the nominated because of many issues. It can be the obligation, it can be the timeline, it can be anything. So always you might face challenges from the contractor by issuing objection to nomination to the engineer because of the deviation from the nominated subcontractor with the obligation towards the employer under the main contract. So there is always a provision and risks that the engineer has to identify to ensure that he's providing the correct information and on the timely manner on the key milestones, set in the program as a baseline. You will always find, if there is a provisional sum, you will find a control milestone where the engineer has to issue this package to the contractor. And they have to provide a room for the contractor for at least 45 days to carry on its negotiation, to prepare its contract documents, to secure the bonds from the subcontractor. So all of this has timeline. So in some of the program, you can see I can see deficiencies or mistakes where the program is built with zero timeline for the contractor to ensure all the documentation are in place. So the contractor felt without any time, is left without no time to just engage himself contractually or review the documents. And the subcontractor will be delayed to provide the bonds on time, insurances, all of these requirements, which the engineer, he will say that's already nominated. Within that date, I don't consider any delays from my side. Yes, I do agree with that. Any other question? Okay, we'll move on.
I think quality of documents in relation to claim, this is one of the other issue.
Sorry, again?
Like the documents that we are using in support of claims, what's the reliability of them? That's, in my opinion, is another issue for frustration. How reliable or how authentic those documents or records are.
Yes, correct. So when the claimant submitting a claim and he's drafting its narrative stating that due to these reasons my project is delayed, he has to provide the proper documentation, because the engineer, and he has to provide the proper quoting of each section. In each section, he has to provide the quoting on the appendices where those documents can be found. So it can be easier for the engineer to cross-check and cross-examine the documents provided. As simply as the engineer, when he's not going to find any backups for those documents, he is going to simply reject your claim, because he got no time to go and find where you have put these documents, where is your site photos, where is your minutes of meeting, where is your notice. He will not spend time on it. Any other question? Okay, shall we move on? So the section 5 is the claim determination. So the engineer duties and responsibilities under the contract. The engineer carry out the same responsibility as the contract has in performing his duties in dealing with the claims. Means the contractor will spend an effort in drafting claims just to meet the requirements of the contract. The engineer carry out the same obligation and the same responsibility. The engineer has to go through the contractor claims, and he has to go one in each event, and he has to provide its technical assessment or why he's disagreeing with the contractor on its claim submitted. So the engineer is deemed to act always for the employer, as we can see in this industry. The engineer got no authority to relieve neither party from its obligation under the contract, nor can amend the contract. The engineer has no right to tell the contractor, don't submit your claim within 42 days, please submit it after 90 days because I'm going for vacation. He has no rights to do that. So the engineer has to ensure that both parties, they're complying with their obligation. So all claims, as you can see here on the chart below, all claims has the same basic requirements. You've got an obligation to carry under the contract. You've got a breach when you breach your contract. So the claimant has to substantiate with its narrative and technical assessment exercise by providing the cause and the effect and the damages. The damages means how much time I have suffered and how much money I have lost. So the breach is actually comes after the obligation, because you fail to carry on your obligation means by default you are under breach of contract. This breach of contract, in order for the claimant to substantiate it, he has to identify the cause, why this is a breach of contract, and what are the root cause of it, and what are the effect on it on the project. So this will give you the sum up on the damages in terms of time and in terms of cost. The engineer determination shall include the basic requirements of the assessment, the requirements and particulars of the contract relied upon. So he has to quote clearly the clause in the contract, why he disagree with the contractor claim. The key information presented and findings. So he has to present the documents and the information he has used in order for him to reach that decision. Justification of the legal and the contractual basis of the claim. The justification that the claimant has not fulfilled its obligation or a risk has occurred that is their responsibility. So he has to explain, as this is the cause, he has to explain why the contractor or why the engineer has breached the contract and has not fulfilled its obligation. As both parties, they are sharing the documents, but the documents, the contract documents is misunderstood or misinterpreted. So each party has a different understanding on the obligation of the other party. The cause is a technical explanation of the cause of the claim events. A technical explanation means the delay analysis. So you go through the event and you explain why there is a cause. The effect is a technical explanation of the effect of the claim. So the causes, I have been prevented or hindered from progressing some works where it's affecting my critical path for 30 days. So the damages redress the delay and the EOT delays. So the damages is in terms of, as you, a contractor by default, when he is delayed, so means that he's going to incur an extra cost. So which the extra cost is going to seek the party who failed to fulfill its obligation, so has to be responsible for the compensation. The engineer should provide an engineer determination to the contractor's submitted claim in a timely manner as set in the contract. The engineer shall not issue an arbitrary rejection without providing its reason with substantiation. Means the contractor submitted the claim and the engineer has to go through all this, his delay event and his quantum section entitlement, and he has to review it and provide an appropriate determination in line with the claims mechanism in the industry. FEDEC allows the engineer to provide its evaluation and determination within 42 days from the date of the contractor submission of the detailed claim. So other bespoke form of contract are silent and does not bind the engineer with a time bar. You might find some other form of contract where you have an obligation of the contractor to submit a notice within 7 days. 7 days, which is very tight timeline for the contractor, considering the dynamic of the site and the workload, the team they are having. So the contracts commercial team, they left with only one option to issue a notice within 7 days. While the engineer, they got the sweet time and they've got no time bar to respond to the contractor claims. So from my perspective, this is a very challenging situation where the contractor has to spend an extra effort and has to inject more team on the project to ensure that all the backups are always recorded. So I would like to ask you guys, what shall be done in this situation? I mean, if you've got a contract where you've got no timeline or time by the engineer to provide its determination, so what shall be done in this situation? How such situation shall be dealt with as an expert in the field? What you shall do? I believe we've got many experts here, so they will give an interesting inputs on this topic. I believe some of you go through this form of contract where they've got no time bar from the engineer to provide its determination? And what did you do in that situation? How did you ensure that your rights is safeguarded all the way till the completion of the project? Okay, we shall move on. I believe that none of you guys went through this situation. I believe this, in my opinion, this has a legal inputs, because there is many provision on the civil code, like the Article 712 and the Article 720, the Article 172. So all of those articles, they provide a clear understanding of how, in case that there is no provision of the time bar in the contract, what contractor shall do in such situation. So here we've got a concrete example of an EOT claim submitted. So you've got here a contract completion date, you've got an overall impact, and you've got impacted the program with mitigation. So if you can see here, the project, this is the starting date, which is the 23rd of December 2015, and the completion should be 1 year after, December 2016, where the milestone 1 is there. Then you've got, this is the first milestone, and this is the second milestone. 2 months after the handover, 2 months after the physical completion date, you need to hand over the complete project with its manual. And you've got here the overall impact. There is a series of event changes, client changes, and you've got delays happening. You've got discrepancies on the drawings. You've got design issues. So impacted the entire project of 336 days impact. Now you've got your program as part of your responsibilities. You have to mitigate. Whenever deemed necessary, you have to mitigate the delays. The contractor, he did its best endeavors, and he mitigated the delays, and he saved 60 days, almost 61 days on the project. And he submitted a claim of 275 days impact to complete the project. So at this claim actually give you an indication on the overall impact on the project identified by the contractor, and how he did its obligation, and he did all the mitigation on the project to reduce the impact on the overall. So here is the physical completion. Here is this is the contractual completion, and this is the physical completion after the mitigation, where the contractor left with 275 delays impact. So through these 275 delays, it might be compensable delays, it might be non-compensable delays. This is based upon the narrative set in the contract, and based on the facts and documents kept by the contractor and reviewed by the engineer. So this section provides an explanation of the EOT and the cost impact submitted. You've got the physical completion, and you've got the handover of the project. We've got an EOT of 275 days taken out from here after the mitigation. And then the engineer has rejected the claim of the 275 days for the milestone 1, and has rejected the completion of the milestone 2. So the cost impact, we consider X cost impact. We can say let's 50 million riyal as a prolongation cost, because of the 275 days, which almost double of the duration that the contractor shall complete its works, and the status of this is disputed. So we can see here the number of days for the engineer to respond. The engineer took 75 days to respond for the first claim, and the 90 days spent to respond for the second claim, which is associated to the handover of the project. So we've got here 3 points where the status is no resolution between the parties. There is no agreement, nothing reached so far. Contractor submitted his claim, the engineer has rejected the claim, and there is no resolution. The project affected by 275 days, and both parties acknowledge that no mitigation can be done. So the course of action is to be decided by both parties, what they need to do, how they have to reach an amicable settlement or consent on these claims. So looking to this scenario, so how do you see the situation where the contractor left with 275 days and there is a rejection issued by the engineer and the contractor is exposed to delay penalties? So what in this situation, what the contractor or what parties should do? Are this leading us to the main topic, why the claims are leading to a dispute? What is your recommendation as a third party or as a CEO of an employer? You are the employer CEO and you need to take a decision. The engineer is telling you that the contractor is providing a fake claim, and the contractor is giving all its backups and reasons that he's entitled for that duration and compensation. What would be your expert recommendation? What will you do at this stage now?
In my opinion, I think a detailed forensic analysis should be conducted, find out various causes of the claim, how legitimate they are, what are contractor delays, what are employer delays, what are excusables, what are compensables. There is no simple solution.
Yeah, I agree. What I'm saying here, I'm trying to say, like, contractor submitted the perfect claim. All this, he did his delay analysis. He did this appropriately, provided all the narratives, all the backups, all the documents. The engineer has rejected. The engineer taking sweet time, 75 days and 90 days to respond to the contractor claim, and the contractor is incurring extra cost, and then the contractor left with no option. Now the contractor and the client the engineer does not know what to do. So
okay, I understand. So it depends on the contract. What's the remedy for dispute resolution? Do we start with mediation, or we straight away go to arbitration or litigation? So contract will determine, but it's next stage of dispute resolution, definitely.
Okay, that's one of the options that can be adopted by the parties after going through the amicable settlement and series of discussion between parties to understand where the disagreement are, in which event, in which section, why this the engineer does not disagree with the delays, why the contractor is considering this as a major, why the engineer is considering as a minor. They need to have an expert to provide their determination. That has to go through the expert witness services and procedures. So I believe in such situation, so the dispute resolution procedures and the contract has to be explored by the parties by providing more time for the amicable settlement and discussion. And in my opinion, the people involved on the project might be appointed on a case-by-case basis to provide their technical inputs. Means that the engineer, if he requires an information, for example, delays due to an MEP, so the engineer has to rely upon the inputs of an MEP expert who got like a massive experience in working in such scale project and provide his opinion. Means opinion, he has to look at the situation and he has to look at the event itself, and he has to look at the submission of the documents by both parties, the information given by the client, and the submission of further shop drawings, material submittals, progress on site, inspections from the contractor, and he has to give its opinion on the issue. He shall not provide any obligation. He's supposed not to interfere on any other deliverables, whether legal or contractual. He has to provide only a technical inputs to the matter. So in order for the parties to understand exactly where the gaps are. So it's not actually a mediation. It's similar to mediation, but it is done under at site level. So I believe there is some of you guys went through these procedures where they've got no agreement on the extension of time and the cost. So where the parties, they have agreed to appoint somebody expert in its field to provide its determination. Is where any one of you guys went through these processes?
We have a question from Chandrasekhar.
Okay.
Yeah, I want to speak actually. Can everyone listen to me? I'm Chandrasekhar here.
Yes, please, go ahead.
Okay. I had gone through such situations during 2009 in UAE during the recession period. I used to work for a client and there are several contracts has been closed suddenly due to the recession. And when I came across to settle these contracts with the clients, because I am from client side and with the consultant and contractors, I used to do this determination. And once the determination has been done, then we used to call the contractors or consultants and show them what is the determination we have done and what are the bases. Several times, I mean 90% of the time, the opposite party does not agree to what we determine. But when we show the details and the proofs and evidence on what basis we did this, then almost 70 to 80% they conclude with our decisions, because no one wants to go up to the arbitration, because before the arbitration there is a expert advice, adjudication. These all procedures are there. But I experienced some of the international consultants from USA, Italy, and Germany. They are gone to the dispute and they gone to the arbitration. And my best experience is one of the USA company went to an arbitration, and after 2 years of several course of discussions through the judge and the legal parties of our company as a client and a consultant, the last question on last day, judge asked to the consultant that have you gone through the assessment made by the client's representative, and this is a document of 50 pages. Have you gone through? And the guy honestly said to the judge that no, we never gone through this because we never believe it. Then the judge said no, I will give you 3 days to go back and see the assessment and come back and tell me you agree or you do not agree, because I personally went through this assessment and it's looked a very good efforts. And this guy then, he came to me personally and within say 6 hours, he agreed and he signed the document of settlement, the figure I gave, because he understood there are a lot of mistakes done by their own parties. So this is my own experience. So this company has issued a notice to those guys who developed these records and said that these practices must be stopped. Generally, the consultant, they take their sweet time, as you said, and they do not, at the end of the day, to protect their right, they develop several wrong things, wrong records. I have found several times the PMC, they are claiming the overtime, working hours of around 10 hours a day, 10 to 14 hours a day for whole month. For whole month, a consultant side, international consultant side, 14 hours a day, he is working for, instead of 22 days, working for 26 days is impossible. It's impossible. I had not seen anywhere. And that is why judge said to him. And then this guy, he agreed to me. So this is my experience. So adjudication is the best experience and it's the best solution for such disputes. The court and arbitrations, most of the companies, especially the international companies, they don't want to go. Because the reason is they spoil the relation with the client, they lose their fame and name in the market. And the third thing, they are not going to achieve anything too much because the time taken to take the decision and the result what they are going to gain, even if they win, the value of it will get reduced after a certain time. If suppose I get 1 lakh, say 1 million dirham today, and if I get the same 1 million dirham after 3 years, definitely the value of 1 million becomes 750,000.
Yes, correct.
Yeah. So these all factors does affect. So an expert opinion is required in such things, and most of the time, the clients as well as the consultants, they even the contractors, they agree to the adjudication. As I mean, if they covers their cost, 99%.
So at the end, both parties they've reached a settlement, so without going to arbitration or any court hearing.
Yeah, 90% of cases are not going to arbitration. I have solved 545 cases. I did the assessment, out of which only 10 cases went to arbitration. Say 500 contracts has been settled mutually.
That's good actually. That's the reason why that there is a many dispute resolution procedures set. So aside to this mediation, adjudication, arbitration, there is other way where both parties they can agree upon amicably, and they will say, look, I've got an expert in each field, so those are their CVs. They are going to look after this claim, and they are going to tell us what is the middle ground. So who's having the right? So they are not going to go to any party. They are not going to discuss any party. Just they are going to scrutinize the documents. So once they give their reports, so they have to sign an initial agreement that both parties they are going to be satisfied with the inputs given by those experts. Or else, if there is no cooperation, no flexibility between the parties, the issue will end up at the court.
Correct.
So
and other important thing, I just want to make one more important thing to mention here. An adjudicator or the assessee who is assessing such disputes should have a good art of amicable solutions to present to both parties. Several times what happens, the disputes, 99% of disputes are unresolved because of ego, as one of the person, Mr. Imran, said it. So yes, it is because of egos. So a mediator must have an ability to explain the consequences if suppose a party does not agree to the solution what we are giving and what they are going to lose it. So then 99% of the parties, they agree because they foresee what they are going to lose if they don't agree.
Definitely, correct. That's the reason why if we go here, I've mentioned this in the slides. If you go to the other section here, I'm saying why there is a frustration, because there is an absence of experts involved in the project. You need to have a contract expert, you need to have a delay analyst, and you need to have a quantum expert. Those people, they will tell you, Mr. Engineer, if you reject this claim unfairly, so the contractor has the right to sue us and he will recover all the losses. So you have to be expert on your field, and the engineer has to have these tools in the project, especially for massive project, to get the appropriate recommendation from the expert in the field to understand where his position is. If the client or the contractor has the right, he has to deal with that situation in a fair manner.
You are right. I finished.
That's the reason. Thank you. I appreciate your inputs. It's really helpful. Thank you very much. Is there any other question, guys? Okay, we shall move on to the next section. Next section, this is a real example from a project where it's giving a positive approach of an engineer who's really wants to deliver the project. So this example is the contractor submitted a claim for a series of events, and he claimed 275 days. This is the example that we've seen, and this is actually the outcome and the narratives extracted from the engineer report. The outcome of the recommendation will enable the project to continue to be administered without the imminent threat of time being at large and affecting the contractor's cash flow, while the contractor's claim is developed to substantiate their entitlement in due course. To that effect, the section below analysis the delay events upon which the contractor's interim claim is based. The assessment of the engineer's representative is documented in the subsequent section of this report. Since there is no contractual requirements to use one type of delay analysis as opposed to another on the collapsed as-built method, the collapsed as-built method is widely recognized and used in the industry. The engineer's representative has carried out further collapsed as-built of the as-built FABB analysis to determine the extent of compensable and non-compensable delays. From the above-mentioned impacted and updated as-built program as of the 22nd of September, the scheduled impact of the excusable delays is retrospectively removed, reduced from the critical path, starting from the most dominant to the least dominant delay event. Here, there is an extract from the analysis and the report of the engineer. It's a PMC responding to the client, to the contractor submitted claim. The way how the analysis is drafted is very professional way, and you can feel there is expert involved by the engineer, and he was tasked to provide an appropriate assessment and determination. The expert inputs as well, if he's seeing a different delays methodology or analysis adopt, which cannot fit the purpose of that project, he has to advise with another methodology, and he has to say the reason why. The engineer has to take out the understanding of, I'm the client, I'm the upper hand, so I have to decide whether to reject, whether to accept based on my relationship or based on the way how the project is dealt with the contractor. No, you have to deal with this in a way that what is provided to you as a documents, what is provided to you as a submission, you have to go through it and you have to analyze it, and you have to respond back to the contractor, explain why he's not entitled for such a claim. That will give the contractor understanding, because the contractor might miss out some of the information. He might not visit some of the documents received. He might miss out some of the transmittal received. So all of this happening, so the contractor will understand better his position when he's receiving a feedback, a response detailed technically and contractually from the employer. So he understands when the contractor, he doesn't receive any feedback or response, or there is arbitrary rejection from the employer, the contractor will feel offended, and he will feel that he has the right for that entitlement. That's the reason why the engineer did not respond to his claim. So this is the approach and perspective of the contractor. However, when the contractor receives such a feedback from the client, and he will understand that the delay analysis, instead of using a window analysis, the engineer choose to go for collapsed as built. So there is a common ground of understanding already, means there is a further room of discussion. Definitely the contractor is not going to accept the whole analysis, is going to challenge some of it. So this is where the parties, they are going to converge into same point where they are going to agree. So as you can see here, as there is no contractual requirements to use the type of delay analysis, means the contract is silent. There is no delay analysis imposed by the contract, for example, saying you have to use as planned, as built, or time impact analysis. So they have the engineer, He's smart in this area, and he knows that there is a contractual gaps as there is no daily analysis set imposed by the contract. So he chose to go through the collapsed as built, and he has the right to do so the same way as the contractor choose to go for the window analysis. So window slice analysis. Here, a subsequent narratives extracted from the engineer analysis, the outcomes of the collapsed as-built analysis intend to provide a clear understanding of all concurrent and parallel sequential culpable reasons of delays, not only due to alleged excusable delays events, but also due to the contractor's culpable reasons of delays. So means here, he's stating that as the claimant, he's putting everything on the shoes of the client, that he's in delays, that's why he's eligible for an extension and prolongation cost. The client said that there is delays based on the documents we have visited throughout the project, and we find out there is a culpability of the contractor. So the client here, the engineer, is explaining the steps used for him to provide this report, quoting that the steps used in the collapsed as-built analysis of the engineer representative is described below. Use the corrected and impacted program as a basis for further assessment. Means at each point of time, when they use the window analysis, the contractor did not rely upon the delay analysis on the reports. He went to the collapsed. Collapsed means the performed works at site, which is giving you more accuracy than what is planned and what is reported. So you might, everybody knows, you might report, for instance, if you are using a PMS system, project management system, you might sometime progress 50%, but you will bill only 40%. The client might show up 10%. 10% might be the reasons of inspection request rejected, might be the reason of NCR, whatever is the reasons. So your payment is short. However, when you update the program, it's technically, we've got a delay analysis or a planning manager with us, he will explain technically the collapsed as-built will give you a better visibility on your work performance. Those people, they will see only the work performance. They are not going to see what is actually built. They will not involve themselves on the commercial matters. It's a pure technical exercise and methodology of delay analysis. So the client, the engineer, choose to use the corrected, impacted program for further assessment. Means at each point of time, each delay event, he choose that window and he collapse the program. He find out that what is progressed was not the same at what was reported at that time. So record, the second point is record the longest path and the origin of the path before collapsing it. So they will know at that time what is the longest path and the origin of it, from which discipline comes this progress. So it's for example, pulling the cables. This is installing of AHU ducts, installing of a chilled water pipe. So they will know that was that the longest path at that window or not. Then they will collapse it. Then they will look after, did the contractor finish 100% of fixing the chilled water pipes, or he finished only 80%? So he will base on contemporaneous record at that time. So the first longest path is recorded as the most driving delay event. So the longest path, what is this collapsed methodology? I'm not going to go deeply on this technical planning and delay analysis matters, but I'm explaining the principles for it. So the first longest path is recorded as the most driving delay event. Means that during that window, they collapse the program and they will cross-check again. Was that the longest path at that time or not? So because these people, they need to identify the culpability of each party. Means there is a concurrency. So they need to identify exactly where is the concurrency based on the collapse, based on the actual progress on site. The third point is expose the next near critical path through collapsing the current longest path by removing all the delays for which the contractor is contractually responsible. So they will collapse the program. They will say, in this month, we've got 15 days of delays from the employer. Let's take out of it out of the program and look at the longest path now. They will see the longest path, and they might see is there is a critical delays or near critical delays by the contractor. So this is whether referred to or not in the contractors. So because contractors sometimes when he uses a window analysis is going to hide his delays, he's going to rely upon a delay which the employer is responsible for. When he collapses this program, everything might change. So that's the reason why the engineer choose to rely upon those methodology. This was done by a combination of fast tracking, reducing lags, and changing the type of logical relationship, and crashing, reducing the duration of critical path activities. Why there is an art here that the engineer is carrying on, is exercise on the proper way, that he changed the logic of the relationship on the program. Because you might choose a month where you've got delays of 10 days, this is compensable delays with the prolongation, and you scrutinize all the delays, and you might find out that there is a lag and there is unlogic between the relationship of the activities. Means it's giving you a wrong indication. If I break the links, so the leading activities will be another activity. It might fall under the contractor culpability, which is by common sense. So you cannot raise something to the employer which is unlogical, and you build your delay analysis and you build your compensation based on it. So you have to have a common logic, even though there is an approved with the program baseline. So you have to reduce the lag and you have to make a logic relationship and explain. Crashing here is actually meaning by the contractor is putting extra resources, okay, to perform its works or to recover its culpable delays. So the contractor might find out on this month he's in delay of 7 days. He will choose that activity. He will inject the extra resources just to catch up with its delays, while he's keeping the employer delays dragging. So this is a smart way how the contractor, they manage the claim when they are just facing issues on the project, and they are building up a backup for them to choose an upcoming cutoff date and submit a claim. So do anyone have a question regarding the determination given or the example we have extracted here? I believe this is the best example. By the way, the claim submitted and the analysis given by the engineer, upon this engineer, the contractor has sent a letter and requested a meeting with the engineer delay expert, and the delay expert and the quantum expert, they came from they flew from Dubai. They spent almost 10 days daily workshop meeting. Myself, I was involved on daily basis, and within 10 days we've reached an amicable consent on the prolongation cost and the revised completion date, and it was sorted out. It's in very good way actually. So that's the reason why I have extracted this matter. This is the fastest claim that we have reached the settlement on it across my career. So it was like the engineer experts was really good in their field. They were very supportive. They understand every single thing that we have raised on our claim. They have visited all the documents, and then they provided their determination after 10 days of series of workshop and going through each details, going through each delay event, going through each minutes of meeting, going through each letter issued, through each daily report. We went even deeply to each email sent by the discipline engineer in the term of a good faith manner. Sometimes, like if you rely upon a letter, sometimes it might be issued after a month, while an email was raised by the discipline engineer on the spot. So we relied upon a contemporaneous record. So we've choose that email as the effective date to build the case. That's the reason of collapse and the benefits of collapsed as build. Do you have any question, guys, about this?
Apologies, maybe I have missed something, but in my opinion, the methodology is adopted to analyze the delays or determine the delay, it makes a huge difference, okay? And there should be a very concrete rationale behind selecting any particular methodology. So this one of the things, like, I couldn't see why these particular methodologies been selected by contractor or consultant and what was the rationale behind it and why they were suited in that particular circumstances.
Okay, so the client, the contractor, when built its claim, he chose to go for window analysis, retrospective analysis based on window slice. So window slice, you will just pick up a cutoff date for the month, and you see the longest path, and you will see the delays happen on that month. What was the delay? Let's say, for instance, the delay is approval of shop drawings. So they will go through that month and they will see the longest path and they will see this shop drawings delay in the approvals. So how much delayed, for example, the procurement, let's say, or delayed the site. So they will say we've got 7 days delays on that particular month. What was the mitigation by the contractor? Did the contractor mitigate that 7 days? They got 2 days mitigation. So the actual delays on that particular month is 5 days after getting the 2 days out of it. As the 2 days is considered as in principles under the contract, is the contractor obligation to mitigate delays whenever possible, whenever applicable. So for that particular 1 month, you've got 5 days, which is compensable days. Means the engineer, the employer has to pay the contractor for prolongation. When you go back to the collapsed as-built methodology, it might give you a different indication. It might give you another longest path, because the methodology used based on the dates of submission and the dates of receipt and the dates of progress of the works. If, for example, most of the contractor, they will use the reason of approval of shop drawings while they are progressing with the works on site and they are awaiting the approval of the shop drawings from the consultant. So they are taking the risk. So this risk, it might have several reasons. It might have because of delays. It might have because of recovery of some other culpability, because of open front activities on site. So when you collapse the progress, the actual progress on site, you might have, you started, for instance, the progress of that works, let's say approval of block work, shop drawings, block work. So you will find on the 15th of this month, I have progressed already with the work, while I received the approval of the shop drawings on the 13th. Means 15 days after I started. When I collapse, I will have different days. I will have different critical path. I will have different longest path. That's why the longest path is more accurate. If I use the window, I will use the date when I have received the approval of the shop drawings. It doesn't entertain when you started the work on the site physically, when you started the work on site. That's why the client, when he goes through this, or the engineer experts, they review the window slide analysis, and then they find out that the contractor was starting with works ahead of the approvals, means the contractor is taking risks, so they collapse these progresses, and then they choose to go for this methodology. So that's the reason why you will have always a gaps. That's correct. So contractor can challenge it, can say, for example, I don't agree with this, as this is my own risk, as if in case that you have rejected your drawings, I will be liable for abortive works. But the essence of it is, parties, they need to reach a settlement. So you have to have always a room for discussion, negotiation, flexibility to reach a settlement, or else you will say, no, I need to stick to the window slice analysis. Please review my methodology. You've got no rights to do that, because no methodology is in the contract. The client, he will tell you, I'm not happy with it. I need to stick with the collapse it has been. So what will be the situation here? It's going to be a dispute. So there is no middle ground reached. Somebody needs to use a methodology, the other party needs to use the methodology. So in order for them to reach a middle ground, so they said, okay, let's agree on it. I will work on that methodology. I have no problem on this. But I will tell you, I consider some of the risk, and I've been requesting documents ahead by emails. Don't stick to the dates where I've issued the letter. And they said, okay, it's fine. We are fine with it. This is based upon the relationship between the parties and how is the parties willing to reach a settlement on it, rather than challenges. I hope this clarifies your question.
Yeah, thanks a lot.
Do we have any other
Mohammed,
question?
we are out of time.
Yeah, we started already 10 minutes, so we are going to move to the next
Unless
slide.
you want to do a complete training, I'm okay with it.
Yeah, it's okay. So this we will have 5 minutes more, so to reach the. This is a section which is the structure of the claim. So how to set up all the mechanism of the claim. The analysis provides the quantum section. So the background of the claim, explain the findings, includes the narrative and explanation, provide your cause and effect. So the discussion here, we reach through going through all of these sections and with the discussion and the question and answers. So based on your experience, what are the documents that parties should rely upon, and what it should be used when? So I believe that everybody is going to answer me the same questions: minutes of meeting, side discussions, correspondences, formal correspondences, emails, anything that has a backup or evidences that might be used as a documents by the contractor and by the engineer to provide this determination. So moving forward to the last section, which is the parties' obstinacy and resistance, means why the claims are leading to disputes. So I want to hear from you guys, what are the main reasons, based on your experience, why parties, they will resist? Why they will resist? Why they will put the project into high risk of dispute? What is the reasons? Do we have any inputs from anyone?
I can say the improper.
Yes, please go ahead.
Yeah, I'm going by. The people deployed on the project are incompetent. That is one of the reasons, which makes a board of directors or the parties higher level to become stubborn, because they give an idea or the decision saying that what we are saying is correct and there are no other consequences. So this is one of the stubbornness is a major issue of leading these claims into the disputes. Flexibility is a must from both parties. So none of the issues will go to the dispute if there is a flexibility. This is my own experience and my view. Thank you.
Yes, correct. Actually, correct. I do agree with the first point that you have raised, is the expertise of the people and the obstinacy of the parties, where they consider themselves as a client, or they are stubborn as a contractor. They are seeking for more time than what they deserve. I do agree with that, definitely. Do we have any other question? Any other inputs?
The other reason I would see that parties take chance, especially contractors. They say maybe we take something out of it, because these things are never black and white, and they think maybe they sell it.
Yeah, correct. So this is not 1 + 1 = 2. So it's actually there is a lot of different ways how you present it. I might give you the same issues, the same events I came through. I will give you 2 claim experts, 3 different claim experts. Everybody will come with different narratives, with different timeline, with different compensation. So it is never black and white. I fully agree with that. But the main reasons is, so I would like to share with you this, these slides. So why many projects lead to disputes in the Middle East? So there is actually a research conducted by E.C. Harris, a consultant company. It's one of the biggest claim consultancies, and they provide as well a dispute resolution services, expert witness services. They did a research about the Middle East, saying that the Middle East region still experiences the largest disputes at the average of $65 million from a global disputes of $500 million. So we are talking about more than 10% of disputes is coming from the Middle East. Those research was based on 3 years research, and they have stated that the reports pointed that several reasons that cause conflict and disputes during 2012 to 2015, which is mostly related to the commercial aspects. The first thing they have identified that they carried different speeches, different trainings, different discussion with experts, and they find out that the failure to properly administer the contract is the most common reasons. We go back again to the same point, which is the experts involved. So as we have highlighted on the first and second slides, this profession cannot be given to a legal people or a technical people or engineers to carry on this task in terms of a contract and commercial management. It's more beyond that, because administering the contract is again an art, and you've got other I can say knowledge, expertise, and attitude that you need to succeed in this profession. So they find out that administering the contract in an appropriate way might reduce significantly the risk of dispute. The second point is the failure to make an interim awards of extension of time and compensation. Means we've got, this is happening if people, they work on a large scale project, which is the duration of it's 3 years and 3 years plus, where the engineer purposely, when he receives an interim claim, he rejects the claim arbitrarily, and he's trying to drag things at the end of the project on the final account, just to exert more pressure on the contractor to agree on a particular figure and compensation. So this is where it's actually raising frustration, and the contractor will proceed with the dispute resolution methodology during the course of the work, and he will ask for an arbitrator or adjudication or mediator to be involved. The third point that A.C. Harris, they find out through their research that the employer imposes changes. The employer, they will never be satisfied with what they have set in the tender documents. They are always keen to change and keep changing and look for perfection design, look for perfection building, then they will never stop for it. And they don't, the technical people, they don't take in consideration the time and the cost impact. They don't take in consideration that the contractor might chase them for the losses and damages has incurred because of the changes. They consider purely on the look and feel of the building and how it looks like in terms of design, and they will never consider the obligation that the contractor has to carry towards the employer. The fourth point is the contract selection was not a best fit when compared to the project characteristics. Sometimes you will find the project is very, very complicated, and it's a typical traditional procurement route where the contractor left without any inputs on the design. It's actually a wrong selection of the procurement route and the contract by the employer. So the employer shall ensure that he's appointing the appropriate QS consultancy and design consultancy to give them their expertise and what is the best that fit their project. The fifth point is the third party or force majeure event, which is happening on the recent years, same as the blockade and this pandemic of COVID-19, some wars like in the revolution 2019 in many countries. This is one of the main reasons that project goes into disputes. So they have also identified that the time consuming and duration also in the process of dispute resolution method is ranked among the longest in the Middle East by 14.6 months. Means everybody knows that there is, if I go for a mediation, for instance, I have the right to don't agree. It's not a binding decision by a mediator and I can escalate it. So in other countries, when they appoint a mediator, both parties, they are going to comply with the decision given by the mediator and they will move forward. So we came across many cases in Doha and in the Middle East in general, where the parties, they will be unsatisfied with the mediator assessment after some time, like 4, 5, 6 months spent on that course of exercise. Then they will escalate. They said, no, we need to go for an arbitrator. Let's explore the further dispute resolution. I'm not in a position to pay you this much of money. So always there is a loss of trust between the parties. That's the reason why dispute resolution methodology, actually the purpose of it is just to reduce the time to reach an agreement between the parties. 14.6 months is actually the same like litigation. It might take 2 years to 3.5 years. So what is the purpose of going through this dispute resolution procedures if the time is going to be more than a year? So that's the reason why AC Harris, they have shortlisted those 5 items, and they say those are the main reasons why many projects lead to a dispute in the Middle East. So you have to bear in mind that whenever there is a project, okay, so you have to ensure that you've got the appropriate team on board to manage the project. And when you are working from a client side, you have to provide an appropriate expert witness to the engineer to make his decision. And you have to make him aware that if you are going to be a party who's not going to apply transparency and fairness, it's going to lead us to a big hassle and dispute. And this project will never be handed over. The same thing, you have to be the key advisor to the engineers and the design team or design firm appointed. Tell them, please, Mr. Design, and don't keep entertaining the employer, because this is going to have a major impact on the completion of the project. And you have to always draft an expert report to the employer stating that, dear employer, we know that you are the paymaster. This is the status of the project. You keep changing. You keep instructing changes. So you have to expect that increase on your budget due to the prolongation cost that is going to be claimed by the contractor, as he has to remain on site more than what was planned, and therefore you have to be ready to avoid these disputes. So all of those mechanisms and all of those issues needs to be taken in consideration whenever you have, whether you work from consultant, from contractor, from PMC, just to reduce the likelihood of any disputes of any project which is not beneficial for any of the parties. Going through the arbitration, through the dispute resolution is not an easy task. It's a very tiring task. It's very costly, and it's going to consume a lot of effort and energy from all the parties. This is actually a chart explaining from the submission of the statement of the claim through the response and the counterclaim from the engineer, case management and hearing, factual legal presentation to decision maker, and result. So this is giving you a cycle for an arbitration or a litigation which might take between 3 to 5 years, and it's not recommended at all. So always people, they have to avoid conflicts, they have to have more discussion, collaboration, collaborative approach to reach an amicable settlement and on the claim. So there is always a flexibility, there is always a series of discussion. We do understand this industry is very frustrating, so there is a lot of emotions on it, there is a lot of challenges, there is a lot of stubbornness, there is a lot of ego, but again, this doesn't mean that you have to push things further and you go to the arbitration and litigation. Thank you very much, everyone, for the attendance today. I do believe that this is very helpful for you. So this is the anything that is required from us. Just please drop a call or an email to Serendip Training and Consultancy. We've got many other trainings. We provide the customized training, bespoke trainings to many contractors, many clients, in-house team. And we provide as well complete trainings for delay analysis, claims drafting, contract management, complete contract management, setting up complete management, contract management and claims procedures for any small scale and large scale contractors, clients, consultancy, PMCs as well. So feel free to contact, please, Serendip Training Consultancies for any more information. Appreciate everybody's time, and I will leave you with the last questions from any of the sections you have here. So I believe we don't have any section.
Yes, you've spoken everything, and I don't need to sell the program anymore. You made life a bit easier now.
Yeah, sure. So anyone is free now to contact you directly. We've got no issue about this.
Yes, thanks a lot, Mo. Thanks a lot. Thank you everyone for joining this webinar. We really hope that you enjoyed it, and we were able to discuss to the best of our abilities. If you have any questions, please share with us. Once we close the webinar, we would be providing you the video of this webinar, so you can always verify. If you want to share with some of the colleagues who could not attend, please do so. And as soon as we have the schedule for more for programs, we'll share with you. Thank you everyone. Stay safe. Take care. Bye.
Thank you everybody. Take care. Bye-bye. Bye.